Good morning. This is the House Judiciary Committee on Sine Die, the 10th of April, 2023. And we have one bill hearing, Senate Bill 505. It is in a significantly different posture as the way it was introduced, I think, Senator, to say the least. So let's hear about what this bill does, please.
Thank you. Thank you very much, Mr. Chairman, Vice Chairman, and members of the committee. Happy Sunday. Here it is. It's done. I'm going to leave right after this because we're busy voting your bills out. So let me ready to go. Senate Bill 505 is a cross-file of HB 660 by Delegate Austin, which had a hearing in this committee back in February. As amended, Senate Bill 505 would expand the eligibility of convictions that qualify for expungement to include driving under the influence or impaired. So it's just PBJ, driving under DWI. The petition for expungement based on a PBJ, probation before judgment, may not be filed earlier than 10 years. Here are some of the changes, I believe. May not be filed earlier than 10 years after the person is discharged from probation. Also, a person may petition the court to shield their court and police records relating to a shieldable offense not sooner than 5 years after they are discharged from a PBJ. Now, just because they petition the court, as you know, it does not mean they will automatically get the expungement nor have their records shielded. Criminal records, as you know, can prevent individuals from employment, housing, educational opportunities. In fact, more than 85% of employees perform background checks on an applicant when they apply for a job. So if you have a past criminal conviction of any kind, it just becomes more difficult for you to obtain employment. Not to mention anything else that occurs after an arrest is documented on an individual's criminal record, and in Maryland, this will remain publicly visible via Maryland case search and until the charges and dispositions are expunged. So in closing, many of us are not the same persons we were when we were 19 and 20. Don't tell anybody, but I know when I was 19 years old in college, I did a couple of things, and thank God I wasn't caught. It will be on my record for the rest of my life. This is one of those things, a few, where it's on your record for the rest of your life. And I'm a person who believes in second chances. I had one. I had more than one. I had second chances, and it got me to where I am today. So this bill is before you in its present posture, and I urge a favorable report, please. Okay.
Are there questions for the Senator? Delegate Kaufman?
Yes, first of all, Senator Muse, it's good to see you.
Good to see you.
And please congratulate your wife on her retirement from Channel 4. I'll miss seeing her on the news every day.
Thank you very much. I can't wait to get out of here so that next week we're going to travel and have some fun for first time in that respect in 33 years.
Well, you all deserve it. So,
thank you.
I know. I know, Mr. Chair, I'm getting to it. My question is, just to make sure I understood, people could only be eligible for expungement 10 years after their DUI, correct?
That's correct.
And
right now it's never.
Okay, that sounds good. But they could only apply for expungement after they, and I support it, but they could only, I'm just trying to understand the bill, because they could only apply for expungement after they have faced consequences for their poor decisions, such as, classes
right.
or other things like that. Okay, thank you, great bill.
Thank you, good to see you again.
So let me ask a question. So in 21902 of the transportation article, it doesn't just include driving under the influence of alcohol, it includes driving under the influence of things like PCP or cocaine or other controlled dangerous substances.
Right.
Would you perhaps agree that driving under the influence of, and that's under Section D of 21902, and Section C is driving under the influence of a combination of drugs and alcohol, or drugs and or alcohol, that those two may be in a separate category than somebody who's driving under the influence solely of alcohol?
Surely, I think circumstances would determine that, and to the discretion of the court and the circumstances. Even at that, to be on your record for the rest of your life, if you're 19, you've got a long time to live. I think at some point, even if it's not at this point in which the bill reflects, at some point they ought to be able to say, I paid my dues. I haven't done it since. It's not, and I just want to move on with my life. I think we're going to have that same problem as we deal with cannabis. So we've got to figure out a way to deal with other than under the influence of alcohol, and I don't have the answer for that because I've not given it a lot of thought, except to say I think that 10 years may be enough.
So the shielding element to the bill, I guess my broader question there, that would shield it effectively from case search, and that is your goal there?
That is my goal, but not from authorities, not from the courts, not from the state's attorney's office. It would still be available to them, just in case that person violated again. After that, it would still be available to the courts.
All right. Delegate Taylor.
Thank you, Chair. Hi.
Hi, how are you?
Doing great.
Good.
To see Prince George is in the house.
Thank you.
How does I do that all the time? How does this differ, if at all, from Delegate Austin's bill?
I think hers may have been, and don't quote me on this, but if I remember, it may have been 7 and 15. And I think it was our committee that put it down to 5 and 10. And I think I may be right on that, and that's the only difference, is the number of years, from 10 to 15. And then the shielding at 7 was, I believe, her bill, and our committee put it back to 5.
Great, thank you.
You're welcome.
Thank you, Mr. Chair. Good to see you, Senator.
Good to see you.
Happy sine die. I'm looking
you.
forward to be done.
Amen.
I'm coming on vacation with you.
Come right on. Let's go.
So I have a kind of technical point here. So I think that most people don't mind the shielding portion because it allows law enforcement prosecutors to continue to have access to the information. If you were to remove it completely, that could potentially change the course of the system working properly. For example, if the information is gone, it might be the difference between a prosecutor pressing criminal charges.
Right.
Is there not value in keeping the information in the system and not completely eradicating it?
There may be, and we did discuss that in the committee, and the committee thought that the list of other offenses, including second-degree assault, all of those things come off in 3 years. They come off in 3 years, and we just thought that for this, that 10 years would be more than enough. That was how they thought.
Okay. All right. Thank you.
Thank you so much.
I'm not sure that second-degree assault, even under the bill that we just passed, would come off in 3. I think it would be in 5 under the bill that was passed.
And you may be right, because I'm not, but I do know it's not the rest of their lives, and that's what I'm trying to
And
get
if it
at.
were a domestically related, but a PBJ is distinct from that, and the domestically related crime would be different again, but anyway.
Thank you.
Let's
Thank
go
you.
Delegate Valentine.
Thank you, Mr. Chair, and thank you, Senator, for this morning. I just want to clarify a couple of points. I think one was one that the chair had said earlier. So this bill in its current form is significantly different. So this only pertains to DUI offenses as opposed to the original bill. Everything else was stricken from what I see.
Right, that's right. It was brought down to just
Completely stricken. My second question is, so that will then significantly impact the fiscal note, because the fiscal note as a written should dramatically reduce because we're eliminating certain types of offenses.
right.
And my last question is, how will this be impacted? I don't have the bill number in front of me, but what we just passed, where all of those years changed that we were working on, what category would this one fall in under? Because the timeframes have changed now. I think it was the Redeem Act that we just passed. So how will this be impacted, and what category will driving under the influence offenses fall under?
Well, again, as far as I can tell from our research and what we said in the committee, this was one of the only ones that could not be expunged ever. So I don't believe that that's in that bill.
Okay.
Did I get the question right?
I think the question is, if the Redeem Act is signed into law by the governor, then what happens, given the way that this is drafted and the way that this appears in the expungement law, would it then fall into a different category? And it might fall into a category where someone would be able to get it expunged within 5 years because it's a misdemeanor. Because they're,
And I don't have the answer to that.
okay.
That was my question. I know with some of the years changing, where this would, what category this would fall under.
I think we would
That
have
was my
to.
Sorry
question.
about this.
No problem, sir.
This isn't listed now in the Redeem Act. Yeah. So this would be on top of what is already there. So to council's point, whatever is in this bill would be on top of the rest. Having said that, in the bill, as I read it, Senator, it simply brackets out the exception for 21902.
Right.
So I think in that context, it could make it a 5-year expungement.
Got you.
Under the other bill. Any other questions for Delegate Cardin?
Mr. Chair, I'm not sure this is for the sponsor. Thank you very much for bringing the bill. But if in fact this specifies, I know it brackets out 902, which one? 2102, but, right, but why would the Redeem Act be implicated in this if it wouldn't,
That has to do with convictions.
so because this is a PBJ, there's no intersection between, there's no
Correct.
implication to this. Okay, I just want to make sure that we're clear that this is a totally separate issue, and the Redeem Act would not have any impact on this.
Thank you.
If it's signed. Okay, thank you.
Thank you.
Mr. Sponsor.
And not a conviction, so it would be, thank you, Mr. Chair.
Are there any other questions for Senator Muse? Seeing none, thank you very much.
Thank
We'll
you.
let
Have
you
you
go back
signed out
across the
everyone
street.
and go
All
back and
right.
get your bills out of here.
Subcommittee chairs, if you go to the conference room, we will have a brief meeting. Mr. Schellenberger? It's a sponsor-only bill.
No one has been able to speak as to this bill because it was changed after the last hearing. And the other thing that's a problem.
I'll give you 2 minutes.
I'm here today with folks from the Washington Regional Alcohol Program, and along with Miss Noah Blonder's mother. Noah was just killed by a drunk driver within the last period of time. I just want to point out how all this came about. On Friday, this was not posted. This was not posted as a hearing until 2:53 on Saturday. I made the mistake of celebrating Easter with my daughter on Saturday, but I went to work on Sunday and I found this, or I wouldn't have been here. I couldn't sign up as a speaker. I could have filled this room with state's attorneys and victims and
If you'd like
witnesses.
to get on the bill, that would be
Sure.
great, because you have a minute and a half left, State's Attorney.
Here's the problem with the bill. There is a reason for why the last 40 years we have not allowed it, the expungement of probation before judgment or DUIs. It's because you drive for 50-plus years. I've seen records where a person got a DUI at the age of 22, then got it at 37, then got it at 55, then got it at 65. And what this says is, when you come in on that third one at 57, I'm not going to know about it. I'm not going to know about it because when it gets expunged, the lawyer and you are allowed to say it's never happened if you're asked. And it's not going to be on the record. I am all in favor of shielding. Shield, that's fine. After 5 years and you never get another DWI, then nobody else is going to know about it except for me. So go ahead, do the shielding part, and let it stay that way. And if you never get another one, there will be no ramifications with anybody. But what does happen is that there are ramifications, because I have people who get 4 and 5 DUIs. And if you spread them out long enough under this statutory scheme, I am not going to know about the third one, the fourth one, or the fifth one, and you'll be able to say that it's not a problem. The other thing that's a problem with this statute is that in one place it says you can't expunge a DUI PBJ for 10 years, but later in the statute, under the regular expungement, it says you can't get the expungement if you have another crime within 3 years of getting the PBJ. This means that if it's passed in the form that it is now, a judge would have to grant the expungement after 10, even if you had another one. So this is fraught with errors. It's all happening too quick. We didn't have a hearing on this form of the bill over in the Senate either. Everything got changed after I walked out of the room. I would urge you to slow down on this. I will work with you over the summer. You can talk to Delegate Moon. He and I have been working for 4 years on facial recognition, and we finally got there. I'd be more than happy to work with you on a reasonable bill with this topic.
Delegate
Thank you
Williams.
very much for letting me speak.
Okay. Thank you, Mr. Scheltenberg, and I understand your concerns. And I don't know if you've read the heavily amended version of this bill, but I think all it does now is shielding, which I think is what you stated you're okay with.
It's not. After 10 years, you can get it expunged,
Okay,
which means
and so
that it's like it never happened.
Right, so that's after 10 years, which if there's no other new DUI after, in between that time period, what's the harm?
Well, the harm is then the 11th year when you get your second one. And then
But how often does that typically happen? Most people who get DUIs usually get them back to back to back.
all the time. I have seen records, and again, if I had had more notice, I could have brought you driving records and shown you examples from all over the state. But we didn't get enough notice to be able to prepare and show this. This was not scheduled until Saturday at almost 3 o'clock. And at that point, I really didn't have the ability to reach out to other states' attorneys and get driving records that I could show you, and how they're spread out over decades.
Right. Well, we have your testimony from the Senate hearing and all of that good stuff in our file as well, so thank you.
Thank you.
Explain to me your 10-year argument, the argument you made at the end of your comment.
So it just seems that it's inconsistent. It says you can't expunge a DUI PBJ for 10 years, but then later in the statute, it says you can't get the expungement if you have another crime within 3 years of getting the PBJ. That's what our normal 3-year wait PBJ is. This would mean that if it passed the way it looks right now, it seems to me a judge would have to grant expungement of the PBJ after 10, even if they got another DUI after the 3. That's the way it's reading to me, is that it might not prevent that expungement after 10 if you got another one after 3.
Where are you looking in the bill?
So obviously, I'm just dealing with, on mine, page 8, where it talks about expungement for PBJ after 10. And then later, in the regular expungement part, I'm trying to find it. On page 10, first line, the petition is based on entry of PBJ, except a probation for judgment for a crime where the act or conviction is no longer a crime. The person within 3 years of entry of probation before judgment and having not been convicted of another conviction may get it expunged. So when you add those, I think it makes it confusing as to whether you can get it expunged or not. But And that's why we need to slow down. That's why we need to not do this on the last day. That's why we need to be able to sit down and talk about it. And I would be willing to help sponsor next year a shielding bill, or you could just strike out the expungement part in this bill and allow it to be shielded after 5 years.
All right. Are there further questions? Delegate Grammer, then Conaway.
Thank you, Mr. Chair. Very briefly, summarize one more time for us how this changes your job practically and the results that may come from that.
Driving under the influence is a very unusual offense because you commit them over a period of time. Like I said, many people drive 50-plus years. I've seen many cases where they haven't had DUIs, but decades apart. And the judge should know that. The judge should know, are you on your first DUI or are you on your fourth? And they won't know that if it's expunged. If it's shielded, they will know it. And that's why I think shielding is better than expungement.
And if we hypothetically were to try and make this workable, in your opinion, the fix would be to strike the expungement and stick with the shielding.
Yeah,
That,
yes,
okay.
and I would be fine with that.
Thank you, Mr. Chair.
How are driving records shielded?
Well, citizens can't get the PBJ record, only I can. And insurance companies can get access to that information, and that's one of the problems. A driving record is a public record, but if you're constantly expunging them, then I won't know about it.
How are driving records expunged?
How are they expunged? If you've gone 3 years without another offense, you can get.
Is that what the law says?
I believe so. I think it's 3
Or
years.
is this under CJIS?
That might be under CJIS, and I'm not familiar with like a speeding ticket when you can get that expunged.
Delegate Conaway.
Thank you, Mr. Chairman. I keep hearing things that seem very strange. What do you mean by your facial recognition comment? What are you guys working on?
I just meant that I am able to compromise and work with folks when we have
You
time.
specifically said that you and the vice chair are working on something with facial recognition, and I'm just asking, what do you mean by that?
That I'm just trying to demonstrate that I'm somebody who can compromise and work on things.
Thank you very much.
Delegate Phillips, then Card, and then we're done.
Mr. State's Attorney, and thank you, Mr. Chair. I just want to make sure I'm clear. On all of these, the State's Attorney still has the opportunity to object to the expungement, correct?
That's correct.
And you don't think that that's sufficient to cover those individuals who may request the expungement if in the State's Attorney's purview they have the right to object?
I think that the vast majority of judges who have a 35-year-old standing in front of them and they had a DUI when they were 24, the vast majority of those cases are going to get expunged. And my problem is I then see them at 42 and it's their second, not their first. And that's what I'm worried about. And that is the reason why, even in justice reinvestment, we did not change the law concerning expunging DUIs. That was a whole thing where we had pages and pages of things that could get expunged, and even justice reinvestment said, no, DUI is different. It's the reason why, for the last 50 years, you haven't been able to expunge a DUI. It's a very unique crime that can take place over many years. And remember what the consequences are when you might be doing your third.
Thank you, Mr. Chair. Just thank you. Delegate Phillips asked one of my questions. So you can object, and it doesn't say that the judge shall allow the expungement. It says he may if there's no other conviction in the 3 years after the initial PBJ.
That is correct.
So it's not that the judge is required to grant the expungement. The judge can choose to do it or not, and you're permitted to object, right?
Correct.
Okay. That's number one. Number two is if somebody is 19, gets a first DWI and gets a PBJ because of it, no accident, nobody was hurt, thank God, everybody was okay. And then at 73, they come back again, which you say happens, or at 58, they come back again. You think a judge should treat them as if this is a serial DWI drinker?
I think the judge should just know, and how they decide to treat them is whatever the judge believes is fair. But the question is, if they have lived an exemplary life and they got a second because it was their retirement party, the judge should know that there was one before and make a reasoned decision. It doesn't necessarily mean they're going to jail. Doesn't even mean it's going on their record. It's just that they should know.
Okay. And how is that different than a second theft over 1,000 for shoplifting when you're 19 and when you're 20 or when you're 73?
Because a theft over doesn't put you behind the wheel of a highly dangerous machine when you drink and could potentially go through a red light and kill somebody.
Okay. All right. Thank you.
Thank you very much. That concludes the testimony for Senate Bill 505. Again, subcommittee chairs, we're going to meet for a moment, then we'll come back out for a voting session in about 15 minutes. Thank you.